All right, so with 420 here, I wanted to talk a little bit about the most common marijuana related issues that we're coming across in my practice. Probably the most common right now that I'm seeing, just because I read so many reports, is the probable cause for a stop. So in the past, what happened was we would read these reports and all the reports would say, I could smell the odor of marijuana emanating from the vehicle. But with the legalization of marijuana, that's no longer probable cause for a search. So now the reports say, I could smell the odor of burnt marijuana. The reason for that is it's still illegal to drive down the road and smoke marijuana, and it's illegal to be driving under the influence of marijuana. So that's why the language has changed. Be aware of that. Make sure that you're not smoking when you're driving down the road. Make sure that you're not under the influence while you're driving. Even though we're in Stockton and you can't drive 2 blocks without the smell of marijuana, don't do it yourself, because it does open you up to a possible search. The other issue that we're coming across is possession for sales. It is still illegal to sell marijuana, so we're coming across these reports, and the most recent one I came across, I just did a prelim, I think last week, where my client possessed 3 pounds of marijuana, and the charge was possession for sales. In this case, my client had a grow in his backyard. There was no testimony about the number of plants, but my argument was, if he's legally allowed to grow 6 plants, is 3 pounds a reasonable yield from 6 plants? I would argue absolutely it is. That would not be an unreasonable weight to produce off of 6 plants. The officer didn't know how many plants A, he possessed, and B, how many he was legally allowed to possess. He didn't know how much weight you could pull off of a typical plant. These were outdoor grows, so theoretically it should probably produce more weight, I would imagine. And this is just something that's going to have to be shaken out in the prelims and the trials, and probably eventually up the appellate courts. The last issue that we come across is custody. In the custody cases, we've dealt with this for many years, all the way back to the medical marijuana days, where people come into court and they're arguing about the other side smoking marijuana. Now, as I've heard one judge say, if he has 2 parents, one parent smokes marijuana, one parent doesn't smoke marijuana, he's going to give the preference to that parent that does not smoke marijuana. However, we have another judge who doesn't seem to care all that much about marijuana at all, unless you're abusing it. And that's really what this looks like, is, just like alcohol, if you're abusing marijuana, it's going to affect your custody case. That's just the reality of it. And the other issue is not letting the children see you smoke it. My opinion is, do not let them see you smoke it, but certainly don't smoke it around them. Don't smoke it in the house. Don't smoke it in the car with them in the car. You don't want to send the kids home smelling like marijuana. You're just asking for a fight. But yeah, if you guys have any other questions, put them in the box below. But otherwise, send us your friends and family. Anybody who might have some criminal or family law related issues, we're here to help. Thanks.